Welcome to the Migrant Center for Human Rights Policy Analysis podcast. My name is Sarah Ramey, and I'm an immigration attorney specializing in asylum law. Today we will be discussing the Attorney General's decision in Matter of Negusie. On November 5th, 2020, the Attorney General ruled that the persecutor bar does not have an exception for duress or for coercion. The Attorney General also ruled that the burden of proving that an individual is not subject to the persecutor bar rests with the asylum seeker, and that they must prove this by a preponderance of the evidence. We will look at both of these rulings today with an eye towards helping immigration practitioners and the general public understand the new state of asylum law and how it will likely affect people in practice. First, a brief overview of the facts of the case. Negusie was conscripted into the Eritrean military, and when he refused to fight against Ethiopia, he was imprisoned for 2 years and subjected to persecution. During this time, he was forced to work as a prison guard, where he was preventing prisoners from escaping, taking showers, obtaining fresh air, and guarded them while they were being tortured in exposure to the hot sun. He also had knowledge that supervisors tortured prisoners with electricity. He claims that while he was working as a guard, he remained a prisoner, and that he also disobeyed orders and helped prisoners escape on occasion. Now let's briefly review how this case went up to the Supreme Court and eventually ended up with the Attorney General. The immigration judge found that there was no evidence that Negusie was a malicious person, that he was aggressive, or that he mistreated prisoners himself. However, the immigration judge denied him asylum, finding that he had a reason to know that what was happening constituted persecution, and that he was therefore assisting in that persecution. The BIA affirmed, finding that his motivation and intent are irrelevant to the question whether he assisted in persecution. It is important for practitioners and the public to understand that the courts throughout the judicial process of this case have failed to look at the mens rea or knowledge component in any direct way. This is likely because this was not a clear issue presented in this case. However, practitioners may be able to distinguish their case from Matter of Negusie where their client does not know they were assisting and participating in persecution. For example, if they were children, if they were mentally incapacitated, or simply don't know what the group is doing that they're involved with. So, for example, we could look at the political party BNP in Bangladesh. That party has engaged in persecution of individuals on occasion, but simply giving money to the party without knowing that the party has engaged in persecution would not necessarily constitute, one might argue, assisting or participating in persecution. So in the course of these decisions, as you'll see, the courts recognize that Negusie knew that there was persecution occurring and never really go further into an analysis. So practitioners will need to consider, even if the individual did not know, would it have been reasonable for them to know? And should also look at the fact that in our laws, often, for example, when an individual waives their right to appeal, that waiver must be involuntary and unknowing. Or rather, I should say one or the other. And basically, this case addresses the first of those, the involuntary component, but does not directly address the unknowing component. So the case then goes to the Fifth Circuit, and the Fifth Circuit affirms. It says it's irrelevant whether the individual is compelled to work in this regard. It's irrelevant what the individual's intentions were. And importantly, we'll note that the Fifth Circuit does reference that Negusie knew about the forms of punishment being used by his superior officer. The Supreme Court reversed. The Supreme Court basically said that the Immigration and Nationality Act, or INA, is silent on this issue and therefore ambiguous. The Board of Immigration Appeals, or BIA, failed in the first instance to interpret the statute, and that the agency must do that before the federal courts get involved. So what the Supreme Court said specifically is that the BIA had compared our asylum law to the Displaced Persons Act of 1948, which in the case of Fedorenko, it had been found that there was no exception to the persecutor bar for involuntary behavior. The Supreme Court said that the Displaced Persons Act is different both in terms of its textual structure as well as the fact that it was enacted for a different purpose. So the case gets sent back, ends up at the BIA, and in June of 2018, the BIA says there is a duress exception. It sets out a 5-part test saying that this is a reasonable interpretation of the statute because it fulfills the purpose of the persecutor bar as well as the overall purpose of the Refugee Act. The BIA also said in its decision that it is on DHS to show evidence that indicates the individual has assisted or otherwise participated in persecution in the first instance, and then subsequently that burden will shift to the respondent, the asylum seeker. Several months later, in October 2018, Attorney General Sessions directed the BIA to refer the case to him for review. And Attorney General Barr, now on November 5th, has reversed the BIA's decision. So first, the language of the persecutor bar states that anyone who has ordered, incited, assisted, or otherwise participated in the persecution of any person on account of race, religion, nationality, membership in a particular social group, or political opinion is barred from asylum. There's a similar bar under the withholding of removal provision of the I&A and the Convention Against Torture. There's not a bar to protection under deferral of removal under the Convention Against Torture, which we'll discuss later on in this podcast. The first thing that the Attorney General addresses is the fact that the statute does not include the word voluntary. Okay? So unlike the Supreme Court that said this is vague, it could go one way or the other, the Attorney General said, well, it doesn't say anything, therefore it's not there, right? Because Congress did not write in there is an exception or this action must be voluntary, that's not a possibility. And basically the Attorney General looked at other sections of the Immigration and Nationality Act of 1952 and says that Congress carved out exceptions for involuntary or excusable behavior in other contexts, such as membership in a particular group. The Attorney General then goes on to look at a series of court decisions and legislation, starting with the Displaced Persons Act of 1948, and moving forward through the I&A, the Refugee Act of 1953, the Vietnamese Protection Act of October 28th of 1977, the Holtzman Amendment, looking at Matter of Rodriguez-Majano, which is subsequent to the Refugee Act. That decision was in 1988, and the Refugee Act was in 1980, and looked at how all of these statutory amendments, all of the decisions sort of interpreting these provisions, none of them said that there is an exception for duress or coercion. And so basically the Attorney General's conclusion was that when Congress got to 1996 to pass the Illegal Immigration Reform and Immigrant Responsibility Act, that basically Congress was aware of this legislative and judicial background and consciously therefore did not include the word voluntary or carve out an exception. The Attorney General relies on this principle that if a word is in one place and it's not somewhere else, that was intentional, and that Congress does have the the knowledge and the ability to write this voluntariness provision in. The Attorney General next turns to international obligations, which was a foundation for the BIA's decision in finding a duress exception, and says basically that none of this applies. Okay? The Attorney General doesn't give a particularly good example or reasoning why, but basically to give you a bit of a background on the arguments, in 1951, the United Nations put in place, drafted and signed, ratified the Convention relating to the status of refugees. The United Nations. Further, in 1967, got the protocol in place through enough ratifications by various countries. And the protocol incorporates the convention, right? So the U.S. is a signatory to the protocol, but not the convention, but both of them do apply. And then, of course, those were incorporated into our Refugee Act of 1980. So in the 1951 convention, the language says that if there are serious reasons for considering that a person has committed a crime against peace, a war crime, or crime against humanity, a serious non-political crime, or any act contrary to the purposes and principles of the United Nations, that person is not protected under the Refugee Convention. Now, the argument here, as noted by Justice Stevens in his concurring opinion at the Supreme Court, is that if a criminal defense of duress or coercion applies in the criminal context, that should also apply in the immigration context, because to do otherwise would basically to rule that an individual is not guilty, but then deport them. And the BIA decision, or rather I should say the Attorney General's decision, affirmed a concurring and dissenting decision by a panel member at the BIA, Malthus, when he says that these are two different systems. The criminal system and the immigration system are different. We can't equate them. Okay, now immigration law has been considered to be civil law in the United States, but that doesn't avoid this idea that there's this perverse effect of holding someone responsible for a crime that they've been found innocent of, right? And immigration law typically does not do that. So the other interesting pieces of this argument are that the UNHCR, so the United Nations High Commissioner for Refugees, which is basically the agency in charge of interpreting and implementing the refugee conventions and framework, has said in their background note that countries are encouraged to consider the exception for duress, okay, and that countries should look at all relevant factors. So even though that language is not in the convention, rather, that countries should be considering it. The other point worth making is that several countries have excluded coercion from the persecutory bar, including Australia, Canada, New Zealand, and the United Kingdom. So basically what the Attorney General has done here is he's instituted what's considered in human rights law the clean hands doctrine. The clean hands doctrine basically says you cannot get any benefit if you do not have clean hands. So if you are any way guilty of anything, it doesn't matter if you were tortured or horribly abused, you can't get remedies for those human rights violations. So this is an issue that we've seen in several Latin American countries as they've come out of civil wars over the last couple decades. And in this particular case, right, if you are any way assisted or participate in persecution, it doesn't matter what happened to you, you're not going to be able to get protection in the United States. with the exception of deferral of removal under the Convention Against Torture, which we will talk about towards the end, as that will not protect everybody. Now, the impact of this decision is much broader than just denying access to the asylum system. This decision impacts the admissibility. The persecutor bar is relevant and related to the admissibility of spouses and children, cancellation removal, adjustment status, temporary protected status applications, and naturalization in some circumstances. So this is a pretty wide-reaching decision. There's also a bit of a perverse result in stating on one hand that there's no exception for someone who's engaged in persecution, but that there is an exception for someone who's provided material support for terrorism. There is an exception for someone who's committed a crime involving moral turpitude. There is an exception for someone who's engaged in a human trafficking offense, or where there are serious adverse foreign policy consequences. Okay. So the Attorney General does briefly state that for policy reasons, without going into a lot of details, that might complicate diplomatic relations, there should not be an exception to the persecutor bar. But yet, we have these exceptions in other contexts that are arguably equally, if in some circumstances, not more grave. So turning to deferral of removal under the Convention Against Torture, this is, of course, a lesser form of protection. It does not grant refugee benefits. It does not grant a pathway to citizenship or the ability to reunify with family. Right? It's considered to be a temporary form of protection that basically just stops that person from being deported while they face problems in their home country, and will allow them to work during the time that they're here in the U.S. The individual must additionally prove that the government is responsible for the torture they will face, that harm is torture, not just persecution, and that there's a greater than 50% likelihood that they will face this harm. Okay, whereas the asylum statute requires about a 10% chance. So there are going to be people who will be denied protection, right? Who will not meet this other standard for deferral of removal, whereas they would meet the standard for asylum. Again, we would just briefly note that the Attorney General did not look at a mens rea element, as the Fifth Circuit mentioned, and the immigration judge in the first instance. So the only place we really see any kind of discussion of this is when Negusie argued that persecution requires morally culpable conduct, and the AGs pretty much dismissed this out of hand, saying that it's not relevant, what persecution is, right? You've conceded that persecution was taking place. We're just trying to figure out right now if you've assisted or participated in that persecution. So this idea of knowledge on, does somebody need to know, or is there at least a requirement that the person should reasonably be expected to know that they're assisting or participating in persecution, is still in some ways a very open question. The last point I'll make is that on this issue is that the Attorney General points to the cost to DHS of conducting investigations and verifying, whether or not someone has engaged in persecution on some level. The idea here being that it will be difficult to verify, conduct human rights investigations in other countries. DHS often doesn't have the authority to do this. These cases are confidential, especially where individuals are fleeing from their government. There would be a direct conflict of interest. However, what's interesting to note with this, while all of this may be true, is that the Attorney General ignores that the asylum seeker, is going to have the same difficulty and the same costs. And the difficulty may be more for them because they may not have the economic means to do any of this research, and they are often in detention, and it's very, very difficult to do any type of evidence gathering from inside an ICE detention facility. So this brings us to the second part of the Attorney General's decision, where he discusses the burden of proof. So as mentioned previously, the BIA stated that DHS has the initial burden to show evidence indicating assistance or participation in persecution. And basically that there must be sufficient prima facie evidence. Okay. Then the burden will shift to the applicant to show by preponderance of the evidence that the bar does not apply. The Attorney General basically scrapped this rule. The Attorney General said the applicant bears the burden of proof, more or less in the first instance, as long as there is some evidence that the bar may apply. Okay, this sounds like a very low standard. And basically, when we look back at the case law, it's not clear what this initial showing of evidence it needs to be for the applicant to then have that burden. And we would suggest that practitioners really look at this issue, because once the burden has shifted to you or falls on you to show by preponderance of the evidence that the bar does not apply, it's going to be an uphill battle. So the First Circuit and the Second Circuit, as well as the BIA, in matter of SK and matter of AH, have all said that the burden rests initially with DHS. Okay, but they don't really say what DHS's burden is specifically. And so what the Attorney General has said is that burden, number one, is not just with DHS, but basically is a low burden. And as long as there's some evidence, whether that's from DHS, the respondent, or the judge, or somehow in the record somewhere, right, then that burden shifts. So the Fifth Circuit has said it's not clear, right? The Fifth Circuit just says there's nothing that says DHS has the burden. The Eighth Circuit says the burden is actually on the respondent. And the BIA also said similarly in a decision from 2017, matter of MBC, the BIA basically said if the evidence indicates that the bar may apply, then the burden is on the applicant. So the BIA still is using the statutory language, right? The statute at 1240.8d says if the evidence indicates that one or more of the grounds of mandatory denial for the application of relief may apply, the alien shall have the burden of proving by preponderance of the evidence that such grounds do not apply. Okay, there's a similar provision for withholding of removal at 1208.16d2. So with that, we will wrap up our discussion today. We encourage all of you to send any questions you have to us via our website at migrantcenter.org and to sign up for our newsletter. Thank you for tuning in today and have a great day.